Alex Warren Green on behalf of Ms. Bonfa-Chan. Please state your name.
Julie Bapachan.
Your Honor, this time we're asking the court to set the matter for a preliminary examination. If I may address bond.
Sure.
Thank you, Your Honor. Ms. Bonfa-Chan was last before the court a week ago. That time she was remanded for bond violations. I believe she had 2 missed tests and a positive test.
That and lying.
Of course, Your Honor,
Okay.
and that's
Okay, go ahead.
Ms. Bonfa-Chan does wish to apologize to the court today for being dishonest at that time. She's assured me that she will continue testing, that she knows what she needs to do, that if her phone wasn't working or anything else like that, that's really not an excuse to miss testing. She's fully employed, sorry, Your Honor, and cares for her 2 children. Right now, her 2 children are living with her sister, so we're just asking the court to consider.
Right from the start, this hearing takes a bold turn. She's asking the court for a bond reduction. But let's take a moment to break that down. This is the same defendant who skipped mandatory drug tests, misled the court, and ignored multiple conditions of her release. Now, standing before the judge, she's hoping for leniency. Her reasoning? She's employed and has children to care for. And while those are valid responsibilities, they don't erase the fact that she broke the rules that were clearly laid out from day one. The courtroom isn't just about personal circumstances. It's about accountability, actions of consequences, and trying to walk back on them after being caught rarely works in your favor. Let's see how the judge responds to this request, because this one's far from a simple yes or no.
I'm sorry.
Go ahead.
If her children are living with her sister, then I'm really concerned because I do have note that she called the victim 41 times. And my understanding was the only reason to
Excuse me?
contact the victim was to have contact with the children. So if the children are not with the victim, then I am concerned.
The Daniel Gray, I have listed as the victim.
Correct.
Sounds
There is contact allowing for conversations about the children. That was my understanding of the bond conditions. So if the children are with her sister, I see no reason for her to have contact with the victim.
Here's where things take a sharp turn, and not in her favor. The judge suddenly pauses and asks a critical question. Hold on, the children aren't even living with the father? And just like that, the entire defense strategy starts to unravel. That one overlooked detail shifts the whole perspective. The calls she claimed were about childcare? They're now under serious scrutiny. If there's no custodial reason to stay in contact, then those phone calls aren't about parenting. They're potential violations. The judge instantly picks up on the contradiction, and the courtroom energy shifts. What started as a plea for understanding now looks a lot more like someone caught bending the truth. Let's get back in and see how the court handles this sudden twist.
The conditions that I have is that the only communication that would have been allowed with the victim regarding the children would have been by text.
There have been 41 phone calls.
Your Honor, that's the first I've heard of her making any phone calls from the jail. My understanding is that the children are living with Ms. Bonfa-Chan's sister and that they do spend time with their dad, who's the complaining witness in this case as well. And prior to her incarceration, it sounds like she did have contact with her dad for purposes of raising the
With
children.
who?
With
Mr.
the
Grant.
children's dad, the complaining witness in this matter.
Right.
Yeah.
That's 41 calls this week.
41 calls since she's been taken into custody. That
Oh, dear God.
41 calls. That's right. 41 separate phone calls from jail to the complaining witness. And the look on the judge's face? It says everything without a single word. Pure disbelief. That, oh dear God moment wasn't just dramatic. It was a real-time reaction to something that's hard to explain away. This isn't a minor slip-up or one emotional mistake. We're talking about a repeated, deliberate choice, dozens of times. In the courtroom, that kind of pattern doesn't look like miscommunication, it looks like defiance. At this point, the defense doesn't just have an uphill battle, they're trying to climb a cliff with no rope. Let's head back in and see how the judge responds to this courtroom bombshell.
We never argued or anything. It was just straight about the kids.
Counsel,
Well, Your Honor, that's the first I've heard of it. I don't think
do
Ms.
you
Vaughn.
want to talk to her about it? Because, I mean, here's the problem. Problem is her bond conditions are that she could only communicate with that individual by text. I realize being in custody, that may not be able to happen. But then the only communication that can occur via text is it has to be regarding the children. You got 41 calls to this person. I have 41 calls to this person and then find out that the person that would be caring for the children is not this person, is not the victim. That's a problem. Just on the face of it, it's a problem.
I understand that, Your Honor, and I know Ms. Fonfachan's primary.
I hate to do
concern
this
is
to the
for
sheriff's
children.
department. Why don't, because theoretically, she may have been released. But this throws a whole new light on everything because she hasn't been doing any, I mean, she's just making her own rules, which is really part of the problem with how she got herself in, outside of lying to me. And now, and not following her bond conditions. And then now I got another one, potential. So let me do this. The sheriff's office would be so kind.
This is the part that really lands, and not because the judge raises her voice. In fact, it's the opposite. Her tone stays low, steady and controlled, and somehow that makes it even more intense. It's not an outburst. It's that quiet, simmering frustration of someone who's clearly been down this road too many times before. You can tell she's not just responding to this defendant. She's responding to the cycle. The excuses, the defiance, the repeated court violations. It's a pattern she's likely seen play out in courtroom after courtroom. And now, she's done playing by the usual rules. She's taking control, and the message is crystal clear. This isn't just a slap on the wrist anymore. Let's jump back in and see how far this burn goes.
Case people versus Dr. Strong.
Assistant Prosecuting Attorney Morgan Barroso, Behalf of Legal.
And Alex Warren Green on behalf of Ms. Fonfachan. State your name again.
Julie Bompachan.
Thank you. Your Honor, I had an opportunity to speak with Ms. Fonfachan. I addressed the phone calls with her. And, Ms. Fonfachan doesn't deny calling the complaining witness in this matter. I don't know the subject matter of those calls, but what Ms. Fonfachan tells me is that subject matter, when those calls are reviewed, is going to come back largely regarding the children, and that the discussions they were having were about the children. The children are staying with her sister while the complaining witness is working. That is filling the void left by Ms. Fonfachan being in custody. Before Ms. Fonfachan was in custody, the children would stay with her while the complaining witness worked, and when he wasn't working, would stay with him. So that arrangement is the same. It's just that Ms. Fonfachan's sister is taking care of the children while the complaining witness is at work. So
Everyone's trying to keep a straight face in the courtroom, but let's be real. This case is slipping off the rails fast. The excuse? The calls were supposedly about the kids. But here's the problem. Even the defense attorney won't firmly stand by that claim. That hesitation says more than any argument could. It's like the entire room is holding its breath, hoping the situation stabilizes, while quietly bracing for the crash. They're all acting like things are still under control, but they're clearly not. The narrative's cracking, the facts aren't lining up, and even the legal team seems to be treading water at this point. This isn't just about missed calls or misunderstood intentions anymore. It's about credibility unraveling in real time. Let's head back in and see if the judge calls it like it is.
Ms. Vaughn
Okay, so and you don't know from the people, you don't know the subject matter of the call.
Your Honor, when I saw 41 calls, I was under the impression that they would be related to the children, but that doesn't eliminate my concern.
I know.
And I'm also concerned at her representation that is largely related to the children, which to me leaves room for an understanding that there's other things being discussed as well.
And Your Honor, what Ms. Vaughn tells me is that none of their communications regard the case. None of them are communications regarding what the complaining witness should do or can do or may do. It's nothing to do with that.
Okay, I get that. But all that does is stop additional charges. Right?
Of course.
Or that goes to whether or not there would be additional charges coming from the prosecutor's office. They don't go to what is another violation of the court's order. I mean, just the call itself. I mean, I could even understand if there were a few calls regarding the kids because you can't text because of the position that I can get that. 41?
And here it is, the moment everything shifts. The judge leans forward and delivers a line that slices through the entire defense. You lied to me. How can I trust anything else? It's calm, but it hits like a hammer. This is the real turning point, because in court, once you break the court's trust, the rest of your case starts to crumble, no matter who you are. It doesn't matter if you're a parent, a working professional, or someone with no criminal record. The legal system runs on credibility. And when that's gone, there's no going back. From this moment on, every excuse, every plea, every defense is seen through the lens of that broken trust. And trust me, judges remember. Let's head back in and watch how the tone of this hearing shifts from here on out.
And here's my other problem. And this is the problem that people have when they come before me and they lie. You lie to me, then it's hard for me to believe anything that you're saying. And so if you're saying you're calling regarding the children, are there calls to her sister at least?
I have not checked. We don't have the sister's phone number because
Got
it's
it.
not in the police report.
Counsel, how soon can you get the phone calls to?
I'll send an email request right now.
Pardon?
I will send the email request right now. Usually they get released within a day.
I'll adjourn our probable cause out 1 week to the 14th, 9 a.m. Get the calls over. At this point, I'm not going to set it for exam. At this point, what I'm going to do is then let's do it this way. You wanted it set for exam, correct?
That is correct, Your Honor.
All right. I'm going to give you a probable cause date on the 14th to try to address her bond to see if we can get her out of custody without some other thing happening. I'll set her preliminary examination. I'll set that for the 26th, 2024, 9 a.m. That will be before me. Next week, though, we'll address her bond after you've had a chance to listen to the calls. And right now, she has no way to communicate about her kids at all because she was doing it by text before.
That's right, Your Honor.
And at least pending the hearing next week, her phone privileges, defendant's phone privileges in their entirety are revoked.
The judge doesn't just respond. She takes full control of the situation. Phone privileges? Gone. Completely shut down. Not even calls to her children are allowed at this point. And it's clear this move isn't just about punishment anymore. It's about restoring order. This isn't personal. It's procedural. The judge is sending a message. If you continue to break the rules, the court will tighten every screw. It's not about being harsh. It's about making sure boundaries are respected and consequences are enforced. Let's see how the defendant reacts now that every safety net has been stripped away.